Hello, friends. This is Verity Seeker, and I'm your host, Mark Powls. We have written constitutions specifically designed to prevent all governments from becoming abusive to the people. But our Republican system of self-governance has been replaced by a British-style common law legal system where laws are passed and left to the courts for interpretation. Sound familiar? Generally, it is based on political agenda, ideological bias, case law, or common law, none of which are a constitutional approach to presenting court opinion on a law requiring pursuance to a written constitution. For years, I told pro-lifers in my county that there was never a national law protecting the institution of abortion, and no one has ever shown me a written law protecting the institution of abortion. First of all, the U.S. Supreme Court never had a constitutional power, or most importantly, a constitutional jurisdiction to hear the case of Roe v. Wade on abortion. It has always been a state issue under state jurisdiction and control. Nowhere in the U.S. Constitution does the U.S. general government have an enumerated power to interfere or regulate the internal affairs of any sovereign independent state in our union. To clarify the truth behind what I just said, let's review some things about our system of self-governance so we can understand the value them both amendment proposal. Notice I'm using a certain language. First of all, what is a state? It is a sovereign, independent country. Okay? That's weird. The state of Kansas, we're dealing with my state, Kansas, is a country. You'll never hear me refer to the United States of America as my country. You will always hear me use the terminology this union, the union. Okay? That is the United States of America. My country is my state. So when I say country, people misunderstand me. But do not misunderstand me. When I say country or state, I'm talking about the state of Kansas, the country of Kansas, because that's exactly what it is. It is a sovereign, independent country. We have 50 of these countries voluntarily participating in a united compact we call a union. So, if the state of Kansas is a sovereign country, then what is the federal government? It is a general government. Okay? I didn't just make up that term to refer to the so-called federal government. It is a general government. In the founding period, you would even hear other terms that I'm going to mention that are correct, but it was as difficult for them as it is difficult for us today because we've been conditioned to use all of the wrong terminology when speaking about our system of self-governance, and it's a mistake, and it plays into the hands of the globalists. So if we change the verbiage to the accurate meanings, then we've begun the process of beating the globalists or the nationalists. This will keep things in perspective as we review where the power is and is not. Not one branch of this general government was delegated a power to interfere with the internal affairs of any state or regulate a state's constitution. This relationship between the sovereign countries in this union and its general government is what we know as federalism. And our form of government in its all-inclusive function is a federal republic. The U.S. general government is only supreme as it pertains to decisions made by the U.S. Congress pursuant to its Constitution. The key word is pursuant to its Constitution. We are taught to believe in an entirely different governmental system, which is opposite what I just described and is the reason why we endured 49 years of an artificial national protection on the institution of abortion, an illusion that a law was created by a Supreme Court decision that was never in its constitutional jurisdiction and never legally binding on any other individual or state outside of that illegitimate case. And the U.S. Supreme Court finally had to nullify it for us by judicial decree, what never should have been. Let's get into the value them both amendment. Let's take a look at some of the articles written in 2013 through 2019 to help us understand why the value them both amendment was drafted in the first place. All right, we have the Kansas House passes Pro-Life Protections Act for 2013. It reads, the Kansas House on Wednesday passed HB 2253, an updated version of last year's Pro-Life Protections Act, by a vote of 92 to 31. The bill passed without any of the four amendments and will remove tax breaks for abortionists and tax funding of abortion and abortion training, codify the informed consent already created and in use by KDHE, State Health Department, unify abortion statute definitions, adopt life begins at conception/fertilization as basis for legislation, and improve support for medically challenging pregnancies and disabled children. Now, is that pursuant to Declaration 1 of the Kansas Bill of Rights? All men are possessed of equal and inalienable natural rights, among which are life, liberty, and the pursuit of happiness. The term life is broad and nonspecific to indicate every human life, which can only be defined as when the process of life begins. Therefore, the process of a life naturally begins at conception. Every human life is a continual process from our beginning to the end. If government is responsible, if their primary purpose is to protect the rights listed in the 20 declarations of our Kansas Bill of Rights, I would say that the government is actually creating legislation that protects the unborn as well as every other human life. 656702, and it talks about drugs or devices for birth control or fertilization. And it reads something like this. 656703, abortion when unborn child is visible. And it reads something like this. No person shall perform or induce or attempt to perform or induce an abortion when the unborn child is viable unless such person is a physician. And it's not that they're making abortion illegal. It's that they are creating legislation that will create an environment where the physician needs to take care to provide a protection for that life that is beginning a process of development. Now, government is not responsible for saving our lives at any level. The government's responsible for creating an environment that protects our right to a life. Now, keep in mind that the mother, when I speak of these, the mother is a surrogate mother, and the mother does not have ownership of the unborn. That's considered slavery. It's not property, nor is the unborn an appendage of the mother. Yes, the unborn relies on the food, the feeding for sustenance, but the same can be true when the baby is born. The baby cannot survive, without the help of the mother at that time either. We have 6704, abortion upon a minor. And I'm just reading the first parts of each one of these just so you get an idea what happened in 2013. Before the performance of an abortion upon a minor, a counselor shall provide pregnancy information and counseling in a manner that can be understood by the minor and allows opportunity for the minor's questions to be addressed. Sounds reasonable. Then we have 6705, which deals with written consent of certain persons required before performance of abortion. So there are restrictions on that. It's not like they're taking away the woman's right of autonomy. The government's focused on that life that's in her. The mother, again, is a surrogate. It's bringing a life into this world, and the new life depends on the mother, but is isolated from the mother, and the baby can also have a different blood type. Okay, then you have 6709, abortion informed consent. Okay, these are all reasonable things. No abortion shall be performed or induced without the voluntary and informed consent of the woman upon whom the abortion is to be performed or induced. 6710, materials to be published and distributed by the Department of Health and Environment. Basically, this lists the requirement that the government will distribute educational information. 6711, information where medical emergency compels performances of an abortion. Where a medical emergency compels the performance of an abortion, the physician shall inform the woman before the abortion, if possible, of the medical indications supporting the physician's judgment that an abortion is necessary to avert her death or to avert substantial and irreversible impairment of a major bodily function. Let's skip over to 6715. This act does not create or recognize a right to abortion or make lawful an abortion that is currently unlawful. Partial birth. No person shall perform or induce a partial birth abortion on an unborn child unless such person is a physician and has a documented referral from another physician who is licensed to practice. As used in this section, partial birth abortion means an abortion procedure in which the person performing the abortion deliberately and intentionally vaginally delivers a living, unborn child until, in the case of a head-first presentation, the entire head of the unborn child is outside the body of the mother, or in the case of a breech presentation, any part of the trunk of the unborn child past the navel is outside the body of the mother for the purpose of performing an overt act that the person knows will kill the partially delivered living unborn child, and performs the overt act other than completion of delivery that kills the partially delivered living unborn child. Okay, abortion of pain-capable unborn child. Okay, the legislature hereby finds and declares that A, pain receptors are present throughout the unborn child's entire body by no later than 16 weeks after fertilization, and nerves link these receptors to the brain's thalamus and subcortical plate by no later than 20 weeks. Now, to me, no one can determine exactly when all this happens. That's just a guess, so why bother? What abortionist can determine when a human feels pain? No one has that knowledge, really. Then we go to 6726, abortion based on gender. I'm not going to read this statute because basically it deals with you cannot abort a baby based on gender. Okay. It's crazy. Okay. We don't do that here. 6732, legislative declaration that life begins at fertilization. The legislature hereby finds and declares the following: the life of each human being begins at fertilization. I've gotten to a place here that I just don't like in this particular statute, and it needs to be deleted. And I have reasons for that, as I described at the beginning of this podcast. It says here under the section B, on and after July 1st, 2013, the laws of this state shall be interpreted and construed to acknowledge on behalf of the unborn child at every stage of development all the rights, privileges, and immunities available to other persons, citizens, and residents of this state. All good, comma. Here it is. Subject only to the Constitution of the United States and decisional interpretations thereof by the United States Supreme Court. What they've done here by writing this in, subject only to the Constitution of the United States. Now, I want to say this: the U.S. Constitution was written for the U.S. general government, not the states. The states are countries; they're sovereign countries. They have their own constitutions. Okay, the state has a constitution. That's the one we follow. That directs the internal affairs of our state, our country. There should be no line in here that says subject only to the Constitution of the United States and decisional interpretations thereof by the United States Supreme Court. Delete it, legislature. Now, the next one, 6733. Again, big mistake. Either they're ignorant or they know exactly what they're doing, and they're trying to nationalize our system and get rid of federalism. Federalism is what makes it possible for different people to be able to function together in a union. You get rid of federalism and nationalize everything so it's a one-size-fits-all, and you're going to have problems. Okay, 6733, it says prohibition on certain funding for abortion. It says, right away, it says, except to the extent required by federal law. Wow. The U.S. general government has no jurisdiction in this matter. It does not have constitutional jurisdiction in the internal affairs of the state of Kansas. Why do you put that line in there? Stop. Get it out of there. 6734, school districts. No school district employee or agent thereof or educational service provider contracting with such school district shall provide abortion services. Okay, that's just, and it goes on, common sense. Don't do it in our schools. We're not promoting it there yet. Now, if this was all a statute that was not pursuant to our Constitution, specifically the first declaration of the Bill of Rights, then you could nullify this. I get it. Nullify it. Because you understand that it isn't pursuant to your Constitution. But these items in the statute are protections, requirements, regulations that are pursuant to creating an environment to protect the right for the unborn to complete the life continuation, okay, from the beginning till the unborn is born. See, 6736, no requirement to provide or right to an abortion. It states again, nothing in KSA 2014 Supplemental 65, 67, 31 through 67, 38 and amendments thereto shall be construed to require any state, agency, or municipality to provide or pay for any abortion or as creating or recognizing a right to an abortion. You do not have a right constitutionally or really naturally to kill the life that you have created. This is by CPR News. Kansas Supreme Court rules state constitution protects right to abortion. The Kansas Constitution protects a woman's right to an abortion. The state Supreme Court ruled Friday. I'm sorry, folks. Every time I hear that or read that word ruled, I think of an oligarchy of 7 people in black robes controlling the entire state. We don't elect them, but somehow they rule over the state. They rule over the legislature. Nope, I'm sorry. They don't rule. They don't rule over us. They present opinion. Okay, the landmark ruling, okay, I'm going to change that. The landmark opinion now stands as the, and here we go again, this is they're creating an impression of a law that doesn't exist. And as long as you're going to remain ignorant of the facts, they're going to keep using it. It says here, the landmark ruling now stands as the law of the land in Kansas. They think you're stupid. Please show them you're not. Ignore what they're saying and correct them, please, because they have no basis for why they said that, except they believe that you are ignorant of the truth with no path for an appeal. Really? So you have a ruling, which should be an opinion. You have a law that's been created by a Kansas Supreme Court justice. Somehow out of thin air, they have legislative powers, and they can literally overturn the legislature of Kansas, and no one can appeal it. Wow, that's a lot of power. That's an oligarchy. Because it turns on the state's constitution. Abortion would remain legal in Kansas. How? I don't see how. Even if the Roe v. Wade case that established a national right to abortion, do you now see how stupid that is? You see what they're doing now that we reviewed how things are supposed to work, and you see how they're using the language and they're using media to teach us to believe a completely wrong thing. They're teaching us a myth because they believe you're ignorant. They believe you're stupid, and you're not stupid. Okay, I'm going to read that again. Even if the Roe v. Wade case, which was null and void anyway because it wasn't supposed to be heard and there was no written law that established a national right to abortion, is ever reversed by the U.S. Supreme Court. Not one word of that is truth. It is a lie, and they believe that you are going to continue believing it. Okay? Now this was done back in 2019. This is what is bringing us to the value them both amendment. Okay? Now that you know the truth, you may think differently about this amendment. Okay? This is a myth that you are fighting. All right, and we go down a little further. The decision in which one of the 7 justices dissented cites in its first sentence the first section of the Kansas Constitution's Bill of Rights. Now, this justice nailed it, and this is truth, because he presented a fact and he verified the dissent by using a constitutional fact. And he said, all men are possessed of equal and inalienable natural rights, among which are life, liberty, and the pursuit of happiness. That's it. That's all you need. One justice knew the truth. The rest of them are activists. I'm going to skip all this stuff because we're running out of time. You get the idea. In 2019, that's when the debate continued, and the the pro-abortion side really had no constitutional grounds to stand on. But just in that one dissent, in that first sentence, that's all that was needed. They have no case. You either obey the Constitution, you protect the right for the unborn to live, or you're wrong, basically. There is no argument on the opposite end. It's a duty and a constitutional duty for the legislature to provide this environment to protect the unborn. They were basing the right to abortion on the first and second declaration of the Kansas Bill of Rights. Now, let's read it. Okay, number 1, equal rights. All men are possessed of equal and inalienable natural rights, among which are life, liberty, and the pursuit of happiness. Now, a surrogate mother's bodily autonomy is her right. We can't tell her to take an injection. We can't tell her to cut off her arm. We can't put things in her body, okay, that she doesn't want without her consent. Okay, now, a surrogate mother has a life growing in her that was by choice, but it says here in the first declaration, among which are life. It is government's duty to protect the right to a life, and that would include the life that has started inside the womb of a woman, a surrogate mother, and also the mother. Possibly 2 blood types. These are 2 individuals. We all know that. Anyone who's had a family knows that your children grow up to be distinct individuals, unique in their own way. There can't be a copy. They're not you. They're not your appendage. They're not your property. So I do not see how the number 1 or Declaration 1 protects the right to kill another life that has started within your womb. Just because it's in your womb, that doesn't mean you own it. It's not your liver. It's not your intestines. This was something that was created. Okay? And it took a man and a woman to create that life. Declaration 2. No one should take this seriously. It says all political power is inherent in the people. In other words, we don't actually, as individuals, we don't actually write the political power. The political power is written in the Constitution. We have a written document that binds everyone to that. All political power is inherent in the people, comma, and all free governments are founded on their authority, meaning we elect representatives to represent our power and authority. We elect representatives to do that for us, because if we all tried to do that together, that's not what this means, okay? Therefore, they're trying to connect this to the woman's power, political power to decide whether to kill the unborn, which is inside her womb, or not. Well, it has nothing to do with that. All political power is inherent in the people. Yes, that's where it originates. And all free governments are founded on their authority. We decide who goes in there and are instituted for their equal protection. We elect people to go in there and make sure that our life, liberty, and pursuit of happiness is secured and protected, our right to it. Now, the woman has a right of autonomy, but the life that's growing inside continually, which has a beginning, a definite beginning, is vulnerable. You can't just terminate that life, okay? That's not a privilege. That's not a right that she has. This is a completely different thing. And it goes into this second part here, which actually goes against what they're saying. It says, no special privileges or immunities shall ever be granted by the legislature. In other words, the legislature, all power is vested. The power to legislate and create law is vested only in the legislature, and they don't have special privileges or immunities to go out and just grant whatever they want to whoever they want, which may not be altered, revoked, or repealed by the same body. And this power shall be exercised by no other tribunal or agency. This has nothing to do with their case for the protection of the right to abortion. It has nothing to do with it. Presently, the Kansas Constitution states that the legislature shall provide for the protection of the rights of women in acquiring and possessing property, real, personal, and mixed, separate and apart from the husband, and shall also provide for their equal rights in the possession of their children. The Kansas Supreme Court said in April that this extends to a natural right of personal autonomy regarding abortion. I disagree with this, because if you read it, the legislature shall provide for the protection of the rights of women in acquiring and possessing property. They're talking about real property, talking about personal effects and mixed effects. Okay, they're not talking about babies. They're not talking about life. Okay, separate and apart from the husband. Okay, and by the way, it takes a husband and a wife to create a life. Well, supposedly. And shall also provide for their equal rights with men, equal footing. Okay. Again, it was an equal rights for women type of clause here, and it had nothing to do with the termination of a life being created inside the womb of the surrogate mother. Just reading it, you can tell that that's not what it was meant for. The Kansas Supreme Court, by saying this, is activists. They are behaving unconstitutionally and probably should be impeached for saying such a thing. And by the way, impeachment originates in the legislature. Kansas adopted this constitution in 1859 when abortion was largely, if not entirely, illegal. Well, yes. The actual text of the proposed referendum has yet to be determined, but is being drafted by pro-life legislators and pro-life groups. According to Mary Kay Culp, who leads Kansans for Life, the constitutional amendment would likely declare that the state's legislature will decide abortion restrictions in the state. It would not ban abortion, however. And, you can't ban abortion. What you can do constitutionally is the legislature must provide a protection on the right of the unborn to have a life. There will be exceptions, and that's why you can't put a ban on abortion. We're gradually leading up to the present. Okay, due to the April ruling, pro-lifers warned other Kansas laws limiting abortion could also be at risk of being overturned. In Kansas, abortion is not legal after the 22nd week of a pregnancy, and parents must be informed and consent to their minor child having an abortion. All right, well, anyway, of course we have to skip an awful lot of dialogue and debate over the situation, but now we're finally getting to the Value Them Life Amendment proposal. Okay, they write Value Them Both Amendment, but it is actually a proposal for an amendment. to the Constitution. People don't amend the Constitution. They can vote for a proposal that can be submitted for a vote, a 2/3 majority vote in the legislature. To fulfill this important civic duty, it's important to understand what the value them both amendment does and does not do. Does value them both ban abortion? No. The only thing value them both bans is taxpayer funding and abortion. The text of the amendment to be added to the Kansas Constitution reads like this. Regulation of abortion because Kansans value both women and children. The Constitution of the state of Kansas does not require government funding of abortion and does not create or secure a right to abortion. Now, here's the line that I hate, and I wish that they had left this out completely. It says here, to the extent permitted by the Constitution of the United States. Its Constitution has nothing to do with this issue. This is a state issue. It deals with a state constitution. What you're doing is you're flipping power back to the U.S. general government, which is exactly the opposite that we should be doing. This is what gets us into trouble. Take that out. Take it out. What I've underlined there, take it out, please. Okay, the people through their elected state representatives and state senators, by the way, we don't need permission from the U.S. general government or its constitution to do this. So leave it out of there. May pass laws regarding abortion, including, but not limited to, laws that account for circumstances of pregnancy resulting from rape or incest or circumstances of necessity to save the life of the mother. That's all good stuff. That is all pursuant to the first declaration of the Kansas Bill of Rights. Will this vote immediately ban or deregulate abortion? No. The amendment vote will decide whether current abortion protections in the state's constitution remain in effect. Now, they're referring to the 2013-2014 statutes that regulate abortion. 2019, the Kansas Supreme Court justice presented an opinion, and they called it a ruling, and in their minds, they automatically believed that it was a law, and it somehow undid all legislation pertaining to abortion. No, it does not. It's an opinion, and they had a weak constitutional position on their opinion. It was wrong. The strongest opinion is the First Amendment. And it's not their side, it's on the pro-life side. Because it is government's responsibility and duty to protect and create an environment for the protection of all life. It's very broad. The more specific you get about something, the more openings on the outside of that specificity. It opens up a lot of can of worms. With this broad, sweeping language, where you just have the word life, that covers everything. Okay, it should. Why do we need this amendment? Here they're talking about the 2019 ruling. Big mistake. They called it a ruling. It's an opinion. A 2019 ruling by the Kansas Supreme Court created a nearly unlimited right to abortion in the state of Kansas. No, it did not. A judicial opinion does not create law. It does not create legislation. It does not undo legislation. If the state constitution is not amended, Kansans will be powerless to enact or keep existing common sense protections, such as parental notification, abortion clinic health and safety standards and inspections, late-term abortion restrictions, and informed consent for women. None of that will change just because a Supreme Court justice has an opinion. Six of them had an activist opinion which they could not provide any constitutional basis for. And you had only one that was actually telling the truth and provided a constitutional reference to back up that dissent. That does not change law. Those 6 justices does not change law. It does not undo or supersede what a legislature has done constitutionally, pursuant to the first declaration of the Kansas Bill of Rights. Additionally, without the amendment, taxpayer dollars will soon be used to fund abortions. No, it won't. No, it won't. Supreme Court justices cannot legislate, nor can they overrule the legislative branch of your government. The only reason why they get by with it is because people don't know, and they know you don't know. So they keep doing it. They keep playing you like a grand piano. Stop letting him do it. We are not going to become a permanent destination for abortion like New York and California. The only way that will happen is if you keep believing the lies they tell you. Learn the truth. Tell them, no, shut up. Okay, what does the overturning of Roe v. Wade mean for Kansas? Nothing. Because it never existed. The only way it existed was in your minds. The U.S. Supreme Court decision to overturn, in other words, it wasn't a decision, it was a nullification of a precedent that was wrong and it was unconstitutional. They nullified it themselves because you wouldn't do it. The states wouldn't do it and the people wouldn't do it because they believed that the Supreme Court was supreme. It's an oligarchy of 9 justices. And we don't really have any other government, just those 9 justices, and they create law. No, they don't. That was sarcasm. Okay, the U.S. Supreme Court decision to overturn Roe v. Wade only increases the importance of voting yes on the value them both amendment. As it stands today, unelected judges in Kansas are the ones who will decide the fate of abortion limits in Kansas. Again, tell me, no, they won't. The question before Kansans on August 2nd is clear. An unregulated abortion industry with no limits at all or the reasonable limits protected by the Value Them Both Amendment. Okay, well, you know better now. I don't have to keep yelling at you. The Supreme Court, the U.S. Supreme Court, nor the Kansas Supreme Court have jurisdiction, or they do not supersede the legislative branch. Okay. They can present opinion, and by golly, if they have a problem, they better back it up with very specific constitutional information. Show us where in the Constitution it backs up your position that the legislature was acting unconstitutionally, or they created a law that was not pursuant to the Kansas Constitution. Notice I did not say the U.S. Constitution. I said the Kansas Constitution. How does the amendment impact current laws on taxpayer-funded abortion? Value Them Both would ensure that state tax dollars will not be used to pay for abortions. The legislature passed a law in 2013 to protect state taxpayers from being forced to fund abortion. However, because of the 2019 court ruling, this restriction will soon be struck down unless Kansans pass the Value Them Both Amendment. How will it be struck down if there's no basis for striking it down? The legislature, when they created the statutes in 2013, were, in fact, pursuant to the first declaration of the Kansas Bill of Rights. What about difficult circumstances? Value Them Both and current Kansas law always protects exceptions for the life of the mother. Value Them Both does not limit life-preserving treatments for women who may experience ectopic pregnancies, septic uterus miscarriages, or other rare health issues. These issues are very clearly defined as not being abortions in Kansas statute. Value Them Both protects laws that ensure victims of sexual assault are not left behind. I mean, they're not being overly, they're not oppressing the women. They're not micromanaging their lives. I mean, they have exceptions in this because, I mean, obviously they understand that things happen. So it's not a barbaric, this is the actual wording. Okay, it says, whereas this proposition, this is the first time you'll see it, this proposition to amend the Bill of Rights of the Constitution of the State of Kansas shall be known and may be cited as the Value Them Both Amendment. Now, therefore, be it resolved by the legislature of the state of Kansas, 2/3 of the members elected or appointed and qualified to the Senate and 2/3 of the members elected or appointed and qualified to the House of Representatives concurring therein. Section 1, the following proposition to amend the Constitution of the State of Kansas shall be submitted to the qualifying electors of the state for their approval or rejection. So, again, you're voting on the proposal to do this. You're not actually voting on the amendment. You vote for the proposal. They can still knock it down. It has to have 2/3 majority in order to become an amendment. And I would suggest when it is proposed, if it passes, I would suggest that they strike the line that says, to the extent permitted by the Constitution of the United States. But that line right there just leaves a way for a rogue U.S. general government to supersede the ability for your legislature to actually control the internal affairs of your state. It then becomes nationalized. Don't do it. Okay, the wording goes like this. Regulation of abortion. Because Kansans value both women and children, the Constitution of the State of Kansas does not require government funding of abortion and does not create or secure a right to abortion to the extent permitted by the Constitution of the United States. Take it out. Okay? I'm going to read that again, but I'm going to read this without that line in there, please, and listen very carefully. This is what needs to be done. Nobody will elect me to be in that government, so I can't really get inside and change this stuff, but I'm going to make it public right here. This is what needs to be done. Regulation of abortion. Because Kansans value both women and children, the Constitution of the State of Kansas does not require government funding of abortion and does not create or secure a right to abortion. The people, through their elected state representatives and state senators, may pass laws regarding abortion, including, but not limited to, laws that account for circumstances of pregnancy resulting from rape or incest or circumstances of necessity to save the life of the mother. Do you hear that? That works. Section 2. The following statement shall be printed on the ballot with the amendment as a whole explanatory statement, the value them both amendment would reserve to the people of Kansas through their elected state legislatures the right to pass laws to regulate abortion because there is no Kansas constitutional right to abortion or to require the government funding of abortion. And then it explains here again in the next two paragraphs exactly what the votes will do. A vote for, meaning a vote yes, a vote for the value them both amendment would reserve to the people of Kansas through their elected state legislators the right to pass laws to regulate abortion because there is no Kansas constitutional right to abortion or to require the government funding of abortion. And then they explain what a no vote is. A vote against the value them both amendment would make no changes to the Constitution of the state of Kansas and could prevent the people, through their elected state legislators, from regulating abortion in many circumstances. It would leave in place the newly discovered right to abortion first recognized in 2019. No, I would disagree with that. The Supreme Court justice that ruled or presented an opinion in 2019 cannot legislate. There still are the statutes from the 2013. It's all there. It's not undone. It didn't go away because of that opinion. The legislature can leave it there because the judicial branch does not have authority over the legislative body. When your judicial branch has authority and power to legislate or to undo legislation based on flimsy opinions, you no longer have Republican government. You have an oligarchy of 7 individuals that dress up in black robes. And you might as well just send your legislature home because that's what you have. You have to have direct representative government, and they have to have power over legislation solely. And that's exactly what they have. Okay. Now, to back up what I just said, I pulled this from the Kansas Constitution. And the articles list the power that each of the branches have. Article 2, legislative. It says here, the legislative power of this state shall be vested in a House of Representatives and Senate. Do I need to read that again? No, I should not. It's clear. Let's take a look at the Article 3 of the Kansas Constitution. Now, this deals with the judicial branch of our Kansas government. And what we're looking for is a power that enumerates a specific power over the legislative body. Do not misunderstand the title of Supreme Court. Article 3, Section 1. The judicial power of this state shall be vested exclusively in one court of justice, which shall be divided into one Supreme Court, district courts, and such other courts as are provided by law, and all courts of record shall have a seal. Here's the line. The Supreme Court shall have general administrative authority over all courts in this state. Does it say this? The Supreme Court shall have general administrative authority over the Kansas legislature? No, it doesn't. It says administrative authority over all courts in the state. That means all inferior courts. That's why the Supreme Court is supreme. The definition of supreme in this situation means that it is the top court over the inferior courts in the judicial system. It does not give the judicial branch the power of legislation or oversight and authority over the legislative body. I've read all of Article 3. There is no power enumerated that gives them authority over legislation or the legislative branch. So when a Kansas Supreme Court justice says that the legislature is not appropriating enough funding to our public schools, our government-run schools, and they need to send the money, then the legislature needs to say, I'm sorry, but we've read your enumerated powers and you do not have jurisdictional or constitutional authority over the decision of money. The legislative body should then force the justices to read Article 2 of the Kansas Constitution and learn where that power lies. And where does that power lie? It shall be vested in a House of Representatives and Senate. It didn't say the judicial branch. I know this is a long podcast. I apologize for that. There is no way to cover all this and to make it make sense. My objective was to teach something about how government works. Without understanding how the government works, you can't understand how to vote for this amendment and why things got to this point. That will give you power over this situation. And I'm hoping that it will be passed around to the legislature. People in the for some reason, they just don't understand. And I think it's because we have too many attorneys in there who are not taught anything about a constitution. They believe in the common law, British style, parliamentary system of government, not self-governance, because it's not that way. It's a case law and precedent type of system. They don't follow a written constitution anymore, and it's sad, and it's killing us. That's why the people are being stomped on by government on both ends. The U.S. general government's doing it, and your state government's doing it, and it's destroying our way of life. It's infringing upon all of our rights, and people are going to rebel if we're not careful here. My conclusion is that this amendment is entirely unnecessary, although I will say this, that it will not hurt to vote yes. If it passes, I would highly recommend you contacting the Kansans for Life and contact your legislators who are representing you and beg them to remove the one little sentence, the little few words in there that I talked about that put power back in the general government that actually is going to end up biting you in the butt later. Don't give power to a general government that doesn't have jurisdiction in the internal affairs of your state. The state obeys the U.S. Constitution as it pertains to foreign objects and the interstate trade, the interstate commerce. As the issue of abortion is an issue internal and under the explicit constitutional jurisdiction of the state of Kansas, not the limited and defined duties delegated to the U.S. general government or its constitution. Remember, the U.S. general government's constitution is supreme only as it pertains to foreign objects and interstate commerce. Beyond that, it has no power over the internal affairs and legislation in Kansas. Should you vote for this amendment? I can't tell you what to do. I can't tell you how to vote. Okay, your vote is for the value. Your vote is for the value them both proposal to be submitted to your Kansas legislature as drafted. Only the Kansas legislature can amend the Kansas Constitution, and the correct verbiage means everything. So just strike that one little part. If you vote no, nothing changes with the current abortion regulations because a Kansas Supreme Court cannot perform a negative on your state's legislature. But if you vote yes, you are approving the verbiage that will be proposed to the Kansas legislature as drafted on the ballot. I've stated the facts and provided you with some background leading up to the value them both proposition. A well-informed, wise voter might have issue with a small portion of the language used in this proposal. The well-informed voter will also recognize that a no vote will not change the current statutes regulating abortion in the state of Kansas, because you know that the Kansas Supreme Court cannot overturn legislation based on judicial opinion and a weak constitutional argument. All legislative power is vested in the legislature, not the Kansas Supreme Court. The Kansas Supreme Court has administrative authority over its inferior courts and is not supreme over your state's legislative body. If it were, you would be ruled by an oligarchy of individuals in black robes under a British common law system with the power to legislate and create law, and that's just not true. That's what your opponents want you to believe. But now you know the truth. Stop believing in the lies and allowing the courts to rule and legislate. I think I've said enough, and now it's up to you to decide what to do. This is